this presentation was basically inspired by a recognition that Laches is probably one of the most underutilized tools in family court, especially child support, alimony, property division, collection cases. And it's also, in the experience I've had, and a lot of my experience has been as an appellate lawyer and in dealing with this issue, is that arguments that could have been really good just aren't made because people are confusing Laches. Laches is an equitable defense that basically has three elements. The elements are delay, unreasonable delay, and prejudice. And that's what all the case law tells us. That's what all the case law tells us. But if you look at those three elements, I would submit to you that too many people focus on the first element. You delayed, and therefore, I'm going to claim Laches. And that's not Laches. In fact, I think you're best off getting rid of the first element completely. When I analyze a Laches claim, I don't worry about delay. And the reason I don't worry about delay is I've never seen a case, and I don't think I will ever see a case, where the appellate courts found that there was unreasonable delay, but we're not going to find Laches because there wasn't delay. I don't even know why they have the first test. They have it in there. I don't know how you can have delay without having unreasonable delay. How you can have unreasonable delay without also having delay. But it's a three-part test, and everyone focuses on the first part, and the first part is irrelevant. Laches basically is asking the court not to enforce previous violations of an order on the basis of the party seeking enforcement of that order has rested on his or her rights to the detriment of the allegedly contemptuous party. Sort of a you snooze, you lose defense, which is delay. But it's more than that. It's you snoozed, and I was prejudiced, and therefore you lose. And if you think about it that way, you will be able to bring a good Laches defense, and you will also be able to defend a good Laches defense. Equitable Estoppel. Equitable Estoppel, this presentation is not going to be much on Equitable Estoppel, but you need to know what Equitable Estoppel is if you're thinking about Laches. And the reason you need to know that is that the two look so similar that a lot of the times you're going to claim Laches, and what you really mean is Equitable Estoppel. And that's less often you're going to get Equitable Estoppel confused with Laches. But you definitely need to keep the two clear. Let me just ask a quick show of hands. People who do child support collection cases or defend them where the party was supposed to pay through the court and for 5 years they've been paying, we'll call them mom to be sexist, directly, and then they get to court and the judge is saying, you don't get credit for what you paid because you were supposed to pay it through the court. How many people have encountered that? Okay? Guess what? You had an Equitable Estoppel defense. Equitable Estoppel basically says the parties have reached a different understanding, a different agreement. We're not going to enforce the order because they have this different agreement. The parties apparently have reached an agreement that he's not going to pay through the court. He's going to pay her directly. She happily took the money directly. And if she'd said, no, I'm not taking your money, you got to pay it through the court, he would have started paying through the court. Instead, he paid her directly. Equitable Estoppel defense. Now, I'm not telling you the judge is necessarily going to agree with your Equitable Estoppel defense, but you go up on appeal with it, and I guarantee you, if you've got those facts, the Court of Appeals of the Supreme Court is going to agree. Because that's Equitable Estoppel. When the parties act as if there's a different agreement, and then one of the parties later says, wait, we didn't have this. I want you to, we had this agreement, but I want the order enforced as it was written. Equitable Estoppel says that's not going to happen. And that's why it kind of looks like Laches, because generally what's happening is there's been a delay in enforcing the order, but they're different defenses. Laches has different remedies. Laches stops just the past enforcement of the order. If you've got a Laches claim, it's going to stop past enforcement of the order, but future enforcement of the order continues. So if you've got an alimony order that's permanent alimony and you have a successful Laches claim, it would wipe out all the arrears. But the ongoing would still be owed. On the other hand, if you got an equitable estoppel claim, that not only stops past enforcement of the order, but it also would avoid future applications. So if you had that alimony order, not only would the past arrears be wiped out, but you would have a future alimony obligation. A very good case came out of the Court of Appeals just this year, Kelly. It's referenced in my materials, and it's a typical Judge Anderson opinion, which means it reads like some sort of horn book on these issues. And I would suggest if you all have any of these cases, go read Kelly. Explains very succinctly the difference between equitable estoppel and Laches. The Court of Appeals found both, but because it found equitable estoppel, it also voided future enforcement of the order. And when you get one of these cases in where there's been a long delay in the enforcement of the order, you should be thinking, did the parties have a different agreement that they reached in the interim? Because if they did, then you've got, or even not necessarily a formal agreement, but just an understanding. The Kelly case involved an example where the father was paying alimony and child support, and the children came to live with the father, and the father just said, "Look, I won't go after you for child support. Just just stop, seeking alimony from me." And they seemed to rock and roll under that agreement for a long time. And then 24 years later, mom comes back, or ex-wife, says, "Where's my alimony? Where's my child support?" And that's a classic equitable estoppel. They reached a different agreement. She might not have testified at the trial that, "You're right, we reached a different agreement, but now I want to enforce the old order." But it's very clear from their course of conduct that they'd reached a different agreement. And the agreement was when the kids came to live with him, he wasn't going to seek alimony, child support from her, and he wasn't going to pay her alimony. And if she'd had a problem with that agreement, she should have been in court the next month or two, not 24 years later. Different defenses, I said. Laches is seeking to stop the past enforcement of the order because the party seeking enforcement of that order has rested on their rights to the detriment of the other party. In contrast, equitable estoppel just seeks to void the order entirely because the parties have engaged in a course of conduct or reached an agreement where it's very clear that application of that order would be inequitable. Okay, Laches is an affirmative defense, as is equitable estoppel. And what it means that it's an affirmative defense is, it must be pled. I'm amazed at how many times you get a rule to show cause, someone knows they're going to raise Laches. It's very clear Laches is one of the affirmative defenses that has to be pled under the rules of civil procedure. So if you're defending a rule to show cause on the Laches claim, file your return and allege Laches. And if you're going to raise equitable estoppel, file your return and raise equitable estoppel and plead the facts that because it's a fact pleading, not a notice pleading state, that would lead the court to be able to find equitable estoppel or Laches. If you are bringing the rule, be wary of this, because I can tell you, every case I've handled on appeal involving Laches, there's not been a return alleging Laches, and it's always been tried by consent. If it wasn't raised in a return or in a pleading, and the defending, the alleged contendor gets up and starts talking about delay or anything that strikes you of Laches, get up there and object. Because if you don't object when the first thing that looks like a Laches defense comes in, you are going to implicitly try the defense of Laches, and the Court of Appeals or the family court judge is going to be perfectly entitled to rule on this Laches claim, even though it wasn't pled. Whereas if you get up there and object from ground one, say it's an affirmative defense under Rule 8C, wasn't pled, they can't raise it, court will probably agree with you, and that's a very easy way of defeating a Laches claim. The other side doesn't plead it, you object when it's raised, then it's not going to be raisable. But if you fail to object, and it's pled, and it's raised, you're going to have it tried by consent. So make sure, if you're going to bring a Laches defense, make sure you plead it. And if you don't see it pled, and you're the party, you're anticipating a Laches defense, you're the party bringing the rule, or you represent the party bringing the rule, and you think that a Laches claim could have been brought, and you start hearing something that sounds like a Laches claim, that's the time to get up and object, because if you don't, it's going to be tried by consent. Couple of hints. If you represent the party claiming Laches, what you need to be thinking about is, why is the delay unreasonable, and how did it cause your client prejudice? You got to prove both elements. If you prove one and not the other, no Laches. You got to prove both. So you need to be thinking, if you're bringing the Laches defense, how you can prove both. If you're the party defending Laches, what you need to be thinking is, was the delay reasonable, or why was the other party not prejudiced by the delay? Now, if you can defend both, you're defending the Laches claim, and you can defend both, defend both. But sometimes it's going to be real obvious that you can't defend both. And then what you've got to do is just defend one. If you can prove just one of the two, that either the delay wasn't unreasonable, or the delay was not prejudicial, you win. Both these elements have to be proved. All three, but as we've already mentioned, you aren't going to have unreasonable delay if you don't have delay. So if you're defending this claim, think, how do I defeat prejudice? How do I show the delay is reasonable? If you can do either of those, you win. But the time to be thinking about it, a lot of times the time to be thinking about these issues is before you file the rule. I get some lady calls me up, I got 10 years of back child support, I want you to go collect it for me, Mr. Foreman, and I want you to do it on a contingency fee. And I'm thinking, ka-ching! But then I say, well, why did you wait 10 years? And if they don't have a really good reason, I mention, well, they might have a Laches defense, and I'd rather handle this on an hourly basis. Let them know. Because you need to be thinking about it right up front. Okay, if you're going to bring that rule, and there's a good Laches defense, perhaps you want to negotiate a payment plan as opposed to bringing that rule. Okay, delay, the typical excuses. There is no book, case, whatever, that you can go and find. These are the list of reasons that delay has been reasonable. But if you read the cases, both in South Carolina and other states, they pretty much fall into one of four categories. And those four categories are lack of notice. Okay? A lot of times there's some requirement that has to be done to set the obligation in motion. Emory case, perfect example. Husband was in the military when the parties reach their final divorce settlement, and he agrees that when he gets out of the military, wife is going to get 25% of his military retirement, and he's going to let wife know, in fact says in the order, he will let wife know when he gets out of the military and starts receiving his retirement. Okay? And she said she doesn't bring a rule for 10 years after he's out of the military. And the father says, ex-husband says, Laches. Well, the problem is, he admitted in testimony at trial that he never let her know he was out of the military. So the condition that was required to set the obligation in motion never happened. And lack of notice, if you don't have notice of the provision that sets the requirement in motion, you don't have, you are not going to, that's going to be a defense to Laches. The Kelly case, another lack of notice. In that case, ex-wife was trying to enforce an order that she never served on the husband. That was almost a reverse thinking, but there, his defense was, I never got notice of the order you're trying to serve him with. So look at if there are notice provisions that either party would have had to comply with, either have the order enforced or to have the enforcing party recognize that their rights had vested. That's one way of excusing enforcement. The second is lack of funds. And I've never understood this argument because I think basically it's a baloney argument if you look at it. A lot of times people will say, I didn't have the funds to hire an attorney. And therefore, I sat for 10 years and let my child support obligation add up to a couple tens of thousands of dollars before I finally decided to go hire an attorney and enforce. And always amazes me because a lot of times when they finally do come up with the funds, usually it's at a time when the other person was paying a little bit and they stop paying altogether. And that's when they file the rule. And if you think there would be one time when they definitely had a lack of funds, it would be when they filed the rule, because before they were getting a little bit of money and now they're getting no money. So they file the rule and they say, I didn't file earlier because I lacked funds. Well, that's one of the reasons the Court of Appeals says you can excuse the delay, is lack of funds. So if I'm the attorney prosecuting the Laches claim, I'm bringing the Laches defense, I'm going to look at a lot of issues in cross-examining the party bringing that claim forward to explain their delay. Like, how were they able to come up with the funds? Why couldn't they come up with the funds earlier? Have they bought new cars in the meantime? Have they done major house remodeling in the meantime? Have they put any money towards savings? Did they have any savings? How were they able, if they had no funds, did they come up with the funds for this case? What attempts have they made to find lawyers, maybe handle the matter on a contingency fee basis, or in the past? Because I think the lack of funds argument probably should fail 99% of the time. But if you don't ask the right questions of the person claiming, oh, I delayed bringing the rule for 15 years because I didn't have money, if you don't ask the right questions, the Court of Appeal, they're going to look for any reason not to find Laches. Laches, it's very clear that unless the party bringing the rule has behaved very badly, the court's going to try to enforce the order. So you're going to, if you're bringing the Laches defense, you're going to have to convince the court that there's pretty strong evidence of Laches. If you let the court find, oh, they didn't bring it because they lacked funds, and you don't show that that's a baloney excuse, Court of Appeals, the court's going to latch onto it. You're going to lose on Laches because of lack of funds. But the lack of funds, I literally have never read a case yet where it was very clear that for some reason this person just could not come onto the funds for 10 or 15 years while they delayed, and all of a sudden they hit the lottery, their aunt died and left them the money, and that's how they were able to fund the lawyer. You just don't read those cases. It's just, oh, I didn't have money, so I waited 10 years. Oh, yeah, she lacked funds, so we're going to excuse the delay. And it's a good excuse. It works. You read the case law, it works. But if you actually analyze it, it really should not work very often. Plaintiff's poor health, and I'm using plaintiff to refer to in this lecture and in the material as the party bringing the, trying to enforce the order. But that is a perfectly good excuse for delay. Now, again, 5 minutes. Again, like the delay, lack of funds, probably generally not a good excuse. But they will latch onto it if they can, the court will. So, the Emery case that I mentioned, that lady had fibromyalgia, depression, a number of different things. And the one question that the attorney bringing the Laches claim never asked her is, lady, you were so sick for so long, what happened that enabled you to bring the rule now? That would have been a good question to ask, I think. When you've got somebody claiming, it was my poor health that made me delay 15 years in bringing this rule. Well, when did you get better? How did you get better? What enabled you to bring it now? But recognize that the poor health isn't an argument they'll use, and if it's an argument that you don't defeat, they will use successfully. And sometimes it is a legitimate argument. But generally, I find the lack of notice is a good argument, lack of funds, and poor health, not such good arguments. Finally, inability to locate the defendant. That generally is a very good argument. Okay? A lot of cases, dad will disappear. We've seen those cases. But if that's your claim, he disappeared, I didn't know where to find him, then I think it's helpful if you're going to defend Laches by saying, I didn't know how to locate the defendant. It's helpful to show what steps you made to locate the defendant. If you've got returned mail, if there was a child support obligation that was paid through the court, and the court was trying to enforce the order, and they could not locate. Every time they try to serve the guy at his address, there's nobody there, or he's moved without leaving a forwarding address. If you don't know where he is, that probably is a very good way to defeat the Laches claim. On the other hand, if the person's arguing Laches because I didn't know how to serve him, and he was visiting the kids once a month, probably not such a good claim. In the Kelly case, the lady argued, I didn't know how to serve him. Well, the guy was listed in the phone directories every year that order was in effect. They had kids together. And the Court of Appeals found those two facts very useful in deciding that the inability to locate was not really true. Okay. So delay. They're going to argue delay if they're defending, if you're bringing a Laches claim. One side obviously is going to say the delay is reasonable. The other side is going to say it's unreasonable. The things you should be thinking about is the excuse for delay merely a post hoc justification for this is how I'm going to defeat Laches, or is it something that's borne by the evidence? Is there evidence, again, to support that excuse? And finally, what evidence might support or refute those typical claims of delay? Now, prejudice is the second element, and it's the element that I think doesn't get looked at nearly as much as the delay element, but it's an important element. If you don't prove prejudice, you're not going to prove Laches. And South Carolina, very little case law dealing with prejudice, and none actually dealing with what would be called defense prejudice, which is odd because in my own experience, defense prejudice tends to be more common than financial prejudice. Financial prejudice is the prejudice where the parties change their financial position due to the expectation the order would not be enforced. I'll give you a couple of examples. Man has a child support obligation of $700 a month. Mom shows no inclination to enforce it, so he goes and buys a brand new house, car, whatever, and he's got no funds available. He could argue financial prejudice. I didn't know you were going to enforce the order. You didn't appear to be interested in enforcing the order. I went out and used up all my discretionary money on a house or a car or whatever, and now I can't afford to pay what I was going to pay. Probably work better with alimony than with child support, but that is a typical financial prejudice claim. Better financial prejudice claim is two children, one's $700 a month child support obligation, one child becomes emancipated, so dad starts paying $350 a month. There's no order that says he can do this. He just says, well, I'm paying $700 on two, I'm going to pay $350 on one. Mom keeps taking the $350, doesn't complain, finally files the rule 3 years later. Well, if she'd complained from the get-go, it ain't $350, the order says $700. He could have filed a modification action 3.5 years ago and let the court decide what he should be paying. But she didn't complain. He didn't go to court. He was financially prejudiced. And therefore, that's a financial prejudice claim. Other type is defense, and sometimes referred to as evidentiary prejudice. And you're not going to find that referenced in South Carolina case law, because, as I say, there really isn't any South Carolina case law. But if you read case law from other states, they'll talk about defense or evidentiary prejudice. And that's a prejudice where the parties lost the capacity to defend the claim due to the passage of time. And I'll give you a perfect, it's in the materials, but a perfect defense prejudice claim had against Mr. Magara's, one of his partners or associates, Paul LeBaron. Lady was trying to enforce a child support order in 2004 that guy had started falling out of compliance, according to her, back in 1989. And he paid regularly. He just didn't pay monthly. And he didn't often pay the full amount. Everyone acknowledged that. And she had what she thought were records showing, sort of written records as to what he paid every month. And he had bank records showing what he had paid every month from like 98 to 2004. And these bank records showed what he'd paid, but they didn't match up with her written recollection of what he paid. So it was very clear that her written recollection was inaccurate. And the bank he'd had prior to 1998 had closed, and those records were unattainable. So he could not find out he couldn't prove what he'd paid. He just knew I'd paid something, and her records weren't accurate, and I have no way of getting my records. So before we actually went to trial, we let the judge decide whether Laches was going to apply to those records or not, so we could, 2 more minutes. We could figure out how much, it might make, once we figured out whether the Laches was going to be, we could probably figure out how to settle the case, how much my client owed. And the judge said, yeah, you can't find those records. You've lost the ability to defend that claim. There's Laches for all the years you didn't have those records. And we were then fighting over what he owed from 98 to 2004. They're completely different defenses. You can think about them as being the defense, but they rely on completely different factual predicates. The claim of financial prejudice, basically you're acknowledging the non-compliance, but you're attempting to excuse it. I didn't comply, but here's my excuse. Defense prejudice is a completely opposite argument. I did comply with the order, but I can no longer prove that. What evidence might substantiate prejudice? Because you need to be thinking about this when you're bringing your claim. If the claims of financial prejudice, what change in financial position did the defendant make as a result of the delay? What evidence would support this claim of changed financial position? The claims of defense prejudice, what evidence has been lost to the passage of time? You need to prove more than that. You need to prove that they made attempts to locate this evidence. I've got a Laches case that's going to be going up on appeal. I didn't try. The guy said, I had bank records where my mother actually made the payments. She's dead now. And one of the issues, I'm sure it's going to be up on appeal, is what attempts were made to locate dead mother's bank records showing the payments were made. Why is this evidence material? The mere fact that evidence has been lost to the passage of time is going to matter if that evidence is not material. If the evidence, so you need to, if you're trying to bring a defense prejudice claim, you need to show that the missing evidence is material. And finally, can the issue be proven through other evidence? If you've got your dead mother says you paid in cash, and you've got bank withdrawals showing that you regularly made a $200 withdrawal of cash that you then paid, you claim you paid the mother every Friday. You've got the bank records but not the dead mother. The court might say that evidence is merely cumulative. Disproving prejudice. The claims of financial prejudice, is there evidence to support the claim? You know, the idea that I went out and spent all this money because I didn't think you were going to force the order isn't so valid if you don't have any evidence to back it up. Was the change in financial position reasonable? You know, the court, like I said, is unlikely if you went out and spent a lot of money and incurred a lot of debt because you didn't think mom was going to enforce the child support order. The court's not likely to buy that. On the other hand, if mom is shacking up with somebody, or appears to be shacking up with somebody, and you've got an alimony order that she's not enforced, and you go out and incur some debt and incur some financial obligations, that might make the change more reasonable. The claims of defense prejudice. Is the missing evidence merely cumulative? Is the missing evidence material? And has the defendant made reasonable efforts to locate the missing evidence? In conclusion, Laches is an extremely powerful remedy. In these cases where enforcement's delayed years, decades, you can have tens of thousands of dollars, sometimes even hundreds of thousands of dollars at issue. And the hints I would finally give you really quickly, the claim, if you've got one of these defenses, you need to analyze very quickly. Is it a claim for Laches? Is it a claim for equitable estoppel? Or is it both defenses you're raising? What evidence would support, what was the reason for the delay? Is it supported by evidence or merely a post hoc justification to defeat a Laches claim? And finally, is the defendant's claim of prejudice, is it financial prejudice or defense prejudice? Thank you very much.